Indeed, if there's anything that gets a jury case off to a bad start, this is true in any case, I think, but it's particularly true in a high-profile case, it is a protracted jury selection process, because it inevitably involves a lot of collateral issues and brings a focus on the personalities of the trial participants in a way that many other aspects of the trial do not. Now, this will not be popular with lawyers, but I must tell you that after 21 years on the bench, several years as a lawyer before that, I am no fan of lawyer-conducted voir dire. It usually is a colossal waste of time. It is seldom, I'm going to be unvarnished, it is seldom that lawyers get anything worthwhile in the voir dire process. And judges can get information from jurors a lot more easily. So if there is some line of inquiry that you really do feel needs to be pursued to test a particular juror, to test that juror's preconceived ideas about the case or issues pertaining to it, if at all possible, see if you can get the judge to ask these questions. And if the judge does permit attorney voir dire, use it sparingly. Sparingly. And use it, and this is of course not limited to high-profile cases, but use open-ended questions with the members of the panel. Tell us, Mr. Jones, about leaving your employment at XYZ company to take a job elsewhere. Let the juror, the prospective juror, tell you the story. Don't try to frame the juror's answer. Yes, Ms. Smith, what would you like to see in a juror in a case where you were a party? Let the juror talk, give you the information. Friendly, non-confrontational. That's, I think, good advice in any case, and particularly in a case where your treatment of the jury is going to be front and center, as it is in a high-profile case. Now, what to do when the judge doesn't do what you think is necessary, is not well prepared, and doesn't pursue inquiries that you regard as important in identifying whether a juror has some leaning that prejudges the case? Well, as I said, first ask the judge to pursue the question. If the judge doesn't do so, or doesn't do so in a way that you think is appropriate, you do have to make your record. And usually, I think, the situation would be, if the voir dire process is still ongoing, if it hasn't completed, if it hasn't finished, the judge can be persuaded to ask the question or pursue the inquiry that you feel is absolutely necessary. Now, as I said, these are pretty standard things to think about in every case. In a high-profile case, you need to obtain some sense whether the potential juror can stand up to the kind of scrutiny that a high-profile case is likely to generate. That's really the unique issue that confronts jury selection in a high-profile case. As I said, there was really nothing novel about the way that Judge Ilston handled Barry Bond's case. There was nothing that she did in that case that shouldn't be done in every case one way or the other. Prompt rulings, reasonable and firm schedule. Those will do wonders in any case. It's simply much harder to execute these good case management practices in the high-profile case because of the attention that such a case has. Lawyers and parties often perceive that they have more to lose in a high-profile case. Hence, their incentives to resist the inevitable consequences of firm scheduling are often greater in the high-profile case. And that enhances the importance of good case management in a high-profile case. I'm not sure that that is a correct assessment, however, that lawyers have more to lose by resisting the kind of fundamental and good case management practices that Judge Ilston had very much on display in Barry Bond's case. So it is true that much of the responsibility for managing a high-profile case does fall on the judge's shoulders. But there's a lot that lawyers can do to keep the temperature cool, or at least at a low-grade fever in the case. First, lawyers need to know that if the case becomes a fiasco, they will share the blame, and indeed may be the biggest part of the blame. Good manners are important in every case, but manners are on vivid display in the high-profile case. So lawyers' self-interest in an orderly proceeding. If the proceedings go off the rails, no one looks good, even if you're not the cause of the derailment. Second, lawyers need to recognize the pressures that a judge is under in a high-profile case, and they should avoid anything that is likely to cause the judge to make a mistake that will, in some fashion or other, derail the proceedings. And third, while lawyers too can be under a great deal of pressure in a high-profile case, cooperation with the other side is of even greater importance in a high-profile case. I've had lawyers say that they don't want to appear friendly with the adversary in a case where everybody is looking. It seems to me that is exactly the wrong attitude. You do want to look like a professional who is cooperative with the other side in a case where everybody is watching. Not that you don't want to in every case, but it's of particular importance, I think, in a high-profile case. Well, those are just good practices generally, but they're much more important in a high-profile case because of the stakes. Lesson number 2, open the courtroom. I doubt that if we went around the room, many of you would disagree with what I've said in lesson number 1. You may very well disagree with a lot of this. Maybe the attorney voir dire, I've got some disagreement on, but probably, or at least many, will disagree with this. By definition, a high-profile trial is a proceeding of public interest. So the job of handling a high-profile case involves handling that public interest. Chief Justice Berger wrote some years ago that people in an open society do not demand infallibility in their institutions, but it is difficult for them to seek to accept what they are prohibited from observing. Now, the problem in the federal trial courts, this is not as much a problem in the state courts, but the problem in the federal trial courts, the United States Supreme Court, and most of the courts of appeal, unfortunately in the Ninth Circuit, is that the public is, as a practical matter, prohibited from viewing the proceedings. Rules and practices foreclosing broadcast and video or internet posting of court proceedings is tantamount to a prohibition of public access. How many people can actually go down to the courthouse and sit hour after hour after hour in the entire proceedings? Very few. So they rely upon second, third, fourth-hand accounts. Now, I realize that courtroom cameras have acquired a bad name among some and perhaps many in our profession. This is unfortunate, and I think an ill-deserved disrepute that has carried over to the federal courts, and perhaps even more unfortunately to the Supreme Court of the United States itself. But there is light, or at least a tube of some kind, at the end of the tunnel. And the Ninth Circuit is ahead of the other circuits in allowing access by the broadcast media. In fact, the Ninth Circuit was the first circuit to do so. It was a case in 1991. It was a panel consisting of Clifford Wallace, Thomas Nelson, and Oliver Kelch. They allowed C-SPAN and 3 television stations to broadcast an appellate oral argument. None of those 3 judges, those of you who know them, would identify any of them as radicals in anything, and certainly not in terms of judicial management. And in the years since, there have been, in the Ninth Circuit, 260 Ninth Circuit appellate arguments broadcast, including the one that the Supreme Court just decided yesterday that I understand the Chief Justice spoke about, the argument in the Proposition 8 case that was on the certified question from the Ninth Circuit. In 2007, the Ninth Circuit Judicial Conference authorized broadcast of federal trial court proceedings. That was a resolution that was overwhelmingly adopted on the vote of both the judges and the lawyers at that Ninth Circuit Judicial Conference. It was not immediately implemented because at the time, the Administrative Office of the Courts, or at least the Case Administration Committee of the Judicial Conference of the United States, was looking into a nationwide pilot program. And the Ninth Circuit, I think, wisely decided they didn't want to get too far out in front of the nationwide program. So they did not do anything to implement, or did very little to implement the program for some period of time. Then, of course, the Proposition 8 case came along, which seemed to me and to others to be a perfect case for broadcast, because it involved, obviously, issues of keen and widespread interest, excellent lawyers on both sides. It was a non-jury case, so we didn't have problems associated with the coverage of a case in which jurors are called upon to be exposed. It seemed to have all the perfect ingredients for broadcast. Well, I won't go into, of course, all the circumstances, but you all know that through a series of rather unusual circumstances, the United States Supreme Court intervened not to prohibit broadcast, but to prohibit transmission of the proceedings outside the courthouse. That was the only issue that was before the Supreme Court. And interestingly enough, in that case, the Supreme Court acknowledged in its opinion that which had been known and recognized and never really teased out as clearly as it was in this case, that the Supreme Court itself, either directly or indirectly through the Judicial Conference, does not have the authority to prohibit broadcast of trial proceedings or any other proceedings in the lower federal courts. That expression, lower federal courts, is one that I've never liked particularly, because it includes everything under the Supreme Court of the United States. But putting that aside, the Supreme Court did recognize that they did not have the authority to do so. In the particular Prop 8 case, they hung their hat on what they considered to be the defects in the adoption of the local rule that implemented the program, something that now the Northern District of California has taken care of with the adoption of what is now Local Rule 77-3. But the good news, or from my point of view, the good news that's come out of this is that that experience helped to revive interest in Congress in the subject of cameras in the courtroom. And in September, the Judicial Conference of the United States approved this was September of last year. In September of last year, they approved a 3-year pilot program for broadcast of civil trials in selected districts. The guidelines are set out in regulations that have been issued by the Judicial Conference. There are many limitations with this pilot project, and it's a tentative start, but it is a movement in the right direction. So I think we are at least moving haltingly toward opening these proceedings.